welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the Educational Tribunal Bill 2010. The bill seeks to create grievance redressal mechanism for the rising number of litigation in the education sector. To discuss the issue, I have with me Mr. Sukhdev Thorat, former chairman of UGC, and also Dr. Balvinder Shukla, Pro Vice Chancellor, Amity Business School. Now for the headlines. The Education Tribunal Bill sets up state and central tribunal to tackle the rising number of complaints in the education sector. The Parliamentary Standing Committee recommends a separate mechanism to deal with complaints from the private sector. And the Parliamentary Standing Committee asks the government to assess the magnitude of litigation in the education sector before setting up tribunals. The Educational Tribunal Bill 2010 proposes to set up a dispute redressing mechanism. Under the bill, all disputes involving students, teachers, employees, managements of higher educational institutions and universities will be redressed by the state and central educational tribunals. As of now, most of the disputes are being settled internally by most of the institutions.
If you have a complaint against your educational institution, if the institution is not as per the promised standards or the management of the organization has been unfair to you, you may approach the proposed educational tribunal. The bill proposes effective and expeditious adjudication of disputes in the higher education sector. It also provides penalties for the indulging in unfair practices.
Now, there is a recent judgment of the Supreme Court called the R. Gandhi judgment, in which the court was considering what are tribunals and in which case they can do judicial judgments. And tribunals are by and large, many of them are set up either for speedy resolution or for certain technical competence.
According to the bill, a National Educational Tribunal (NET) will be set up at the center and State Educational Tribunal (SET) will be set up in all states. The State Educational Tribunal shall have the powers to take up issues of unfair practices by any higher educational institution. The State Tribunal will have the power to appeal on affiliation of higher education institutions to universities. State Tribunal will also have the powers to adjudicate service matters of any teacher or any employee. Any person aggrieved by State Tribunal's order can appeal against such order to the National Educational Tribunal (NET). But if there is any dispute between two higher educational institutions involving two state governments, then the matter will have to be taken up at the level of National Educational Tribunal (NET).
Educational Tribunal Bill will tremendously reduce the burden of the courts. The only few things need to be clarified. The state tribunal courts have to attend first the matters from their state. Then the question is, should it go to the National Tribunal Court or should it go to the High Court of that state? I think these some points need very clear clarification.
The National Tribunal will also have the powers to resolve disputes between higher educational institutions and authorities that control the institutions. The order of the tribunal will have the strength equal to the ruling of a civil court. And any violation in implementing the orders of the National Tribunal can be punished with imprisonment up to 3 years. The 2010 report of University Grant Commission has cancelled and declared 21 universities of India as fake universities. The establishment of Educational Tribunal and at state level and at national level will look into matters related to universities and their affiliated colleges. Raj Kamal for Rajya Sabha TV.
Several agencies have pointed out that there is no data available to establish that litigation has been rising in the education sector. The question to you, Mr. Thorat, is there data to establish that litigation of the kind that this tribunal seeks to redress has been rising in the education sector?
I think the litigation have been rising and rising at a very substantial rate. At the moment, there is a mechanism where these issues are dealt by the universities. So only a portion of those now comes to UGC or to the other statutory bodies. But with the expansion of the educational institution, with the expansion of colleges, Universities, we had only 25 in the early 50s, now we have more than 600 universities. We had about 700 colleges in the early 50s, now we have more than 30,000 colleges. And we have private and public now. The private sector is expanding at a very fast rate. You have central university, you have state public university, you have state private university, you have private deemed university, you have public deemed universities. So it's a very, very vast sector, and it remains to a certain extent quite unregulated. So I have a reason to believe that the litigations have substantially increased, and my experience in UGC tells me that a portion of that only comes, and that has been increasing over a period of time.
Okay. And do you think, ma'am, the question to you is, do you think this tribunal will be able to address the rising litigation or rising disputes that are there in the private and the public sector?
I believe that it will definitely help to and also address the issues, because today if there's any litigation happens, it goes straight to the court. Court has its own priorities to handle the issues, and by the time the decision comes, many times it's very, very late, whether it is for the student or for the institution. So I think setting up these state level tribunals or the national level will focus only on education and speed up the process.
Unfair trade practice, sir. Yeah. Unfair trade practice has not been defined in this bill. But largely, how would you explain the term unfair trade practice in context to the education sector?
Now, I think it will be defined when the regulation comes in greater detail. But my feeling is that what is being considered is this, that every educational institution through their prospectors laid down the policies, rule about admission, rule about fees, curriculum, and several other aspects of the degree. Now, what the ministry under this rule expect is that whether you follow what you write in your prospectus or what you promise.
Yeah.
So, under the existing law, these unfair practices will be dealt under the existing law, and that too on the self-declaration by the institutions. So, there is nothing like that coming from the outside.
Yeah.
In your prospect, in your website, you indicate the rules of admission, you indicate the fees, you indicate the courses to be offered, and other thing. Just abide by that. So, I think any violation from that, any deviation from that, which is promised to the student but will not observed, I think will amount to unfair practices in addition to other
This phenomena is more in the private sector than it is in the public sector. Ma'am, I want to bring you in. What is it? What are the constraints where a private university declares certain things, would like to project certain things, but at some level it is not adhered to in practice? In that comes under the purview of unfair trade practice, and it is largely there prevalent in the private sector. You advertise something, but practice something else. So, in that situation, what are the constraints with the private universities which make it compulsory for private sector to go in for, let's say, unfair trade practice?
I would like to put it differently, because expectations which are from the government universities or government institutions and the expectations from the private institutions are fairly different. Because when you view a government institution or government university, you view very differently. The moment you move to the private institution, you view those very differently. But I would not agree that every private institution or every private institution is indulged into the unfair practices or something, because if we start comparing at the very ground level, you will see those unfair practices anywhere and everywhere, whether it's government or whether private. So, we should not label that it's in the private but not in the government.
Sir, I'll bring you, the standing committee has specifically said that private sector complaints should be dealt with separately, and there should be a separate mechanism to deal with it. That's the recommendation of the standing committee. Why do you think the standing committee has said so?
No, I think I would not, I wouldn't know the reasons why the standing committee has recommended separate mechanism, but I think since they have recommended, it's an important committee, and it obviously has gone to the MHRD ministry. I think ministry will give a consideration to it, whichever way it thinks is appropriate.
On that note, it's time for us to head into a break. When we come back, we will tell you about the recommendations made by the standing committee. Welcome back. The proposed bill does not specifically mention that student grievances will be redressed by the tribunal. The department-related standing committee has recommended that the word student should be added so that it is clear that their complaints will also be taken up by the tribunal. The parliamentary panel has also recommended that there should be separate dealing of public sector and private sector complaints.
This is important not for politics, it's important for the future of our children.
The bill presents an alternative system to resolve disputes between teachers and other employees by bringing them to the state tribunals. At present, these issues are settled by employee unions and other internal mechanisms. The standing committee has pointed out several issues that need to be sorted out.
There is a minimum age limit of 55 years for a member. Now, why do you need minimum 55 when actually somebody can become a judge of the Supreme Court at a lower age? You can become the President of India at 35. So why do you need a minimum of 55 to get onto a education tribunal?
According to the standing committee report, the government should assess the magnitude of cases and costs incurred in litigation before setting up tribunals, as there is no available data indicating increase in litigation in the education sector. The committee recommends that it should be made clear that students themselves can seek justice under the bill. The committee is in favor of a separate mechanism to ensure justice in case of a public and private institutions. The committee is of the view that certain provisions of the bill violate the Supreme Court's judgment and should be reconsidered. A recent Supreme Court judgment states that every two-member bench of the tribunal should always have a judicial member. Also, whenever any larger or any special benches are constituted, the number of technical members should not exceed the number of judicial members.
Does not even define in detail the powers of the tribunal. All it says that anybody can approach the tribunal and tribunal will entertain, in fact, the case. Question is, how do you protect the interest of education?
The two-tier structure of educational tribunals was proposed in 2010 to achieve the goals of expansion in higher education to effectively compete with other countries. The government believes that a separate legal entity in education sector will provide quick solutions to disputes compared to the existing internal mechanism followed by the institution. If any university and any college is declared as a fake university by UGC, now those colleges people can go and appeal before the State Educational Tribunal. This can become a threat to UGC and AICT powers. Raj Kamal for Rajya Sabha TV.
How important is it to separate the complaints of the private sector and why? But before we come to this question, sir, I would like to ask you, there is an existing mechanism which has evolved over the years, a mechanism to redress complaints. And there are institutions which are at the top of it and dealing with it. Your institution, of your former institution, has been one of them. AICT is one, and university level also redressal happens. What is the need to replace that system with this new system?
No, I think the every education institutions, either a university or a colleges, they have their internal mechanism. For example, in my university, we have a provost office and all complaints are dealt there. But then there are issues which are not resolved internally. So there is an outlet, there is an opportunity for an employee to go to the tribunal and place the case. So I think this is an important facility.
Which essentially what you're saying is that we have the tribunal and we continue with the existing.
No, we don't have a tribunal. We have a.
No, what I'm saying is
universities have an informal mechanism.
That informal
to resolve the issue, and that will continue. It's not necessary that all cases will directly go to the tribunal. There is an internal mechanism, informal mechanism, where I think many of the cases will be dealt with. But if somebody is not satisfied, then he has an option to go to a higher authority, that is a tribunal, where as per the existing law, he should be able to get a justice.
No, sir, just to bring to your notice that the National Tribunal seeks to take over all such matters, even matters of affiliation, appeals relating to that. Even in the states, they will replace all existing dispute redressal mechanisms and will be the let's say, the authority, all pervasive authority on such matters.
Well, that's okay. If it does that, it's okay. My point is, as far as the affiliation is concerned, it's a very serious issue. I tell you, we have, I think, 31,000 colleges now. The University Grant Commission provide a grant to the colleges which are government and which get a government support. The rest of them are not eligible. So, only 6,000 colleges are being supported by the UGC. But there is one important condition, that you should have a permanent affiliation with the university. Then only you are eligible for a grant. I can tell you, in many state and in many universities, the colleges, they met the condition of permanent affiliation, and yet they do not get the permanent affiliation from the university, for a simple reason that the university will lose the fees, because they charge a hefty fee to give an affiliation on an annual basis. But in the process, the college is deprived of a grant from the UGC. So, I think these are the affiliation, the right to go to the tribunal for the purposes of affiliation, I think this will bring a great relief to the colleges. Lot more colleges will then become eligible for the grant from the UGC.
Now, for example,
because the university will have to justify as to why a college which is fulfilling the condition for a permanent affiliation, which makes it entitled for a grant, is refusing affiliation.
I get it. Yeah. Now, how does it happen in the private sector? The same, you people don't want grant, you people are self-sufficient, you have all the licenses or everything in place, for example, Amity. But if a setup like the state tribunal happens, and if anyone from your organization, whether it be a student, employee, professor, lecturer, principal, even if it is a management that you are contesting, if these complaints start being addressed or redressed by a outside agency, will it impact your institutions?
See, even today when we look at, there are a lot of issues which are resolved in-house, but there are a lot of things which go out and they go in the court. We believe that if there's a tribunal, state level or national level, then it will be focus address, and it will be the experts from who understand the academics as well as the legal people who will be addressing the issues, and they will be fair to the both, whether it's employees or the organization or students or the organizations. So, it will, I feel that it will speed up and it will be the fair practice to all. The only is that unless there's some amount of the corruption comes up as it happens in the other level also, then it will not meet the objective for which serve the purpose for which it's being established.
Right. It's time for us to head into a break. When we come back, we will show you an interview with Professor P.V. Sharma, Vice Chancellor, Delhi Technological University, formerly known as the Delhi College of Welcome back. My colleague Rajkamal Rao spoke to Vice Chancellor of the Delhi Technological University, Professor P.V. Sharma, to understand the importance of the bill.
Sir, do we really need a separate tribunals to solve the matters with educational universities and colleges?
Personally, I do not feel there is a need. We are a country where we create multiple authorities. Already we have a regulatory mechanism in this country whereby the quality and standards of education for professional education are to be enforced by AICTE for engineering and technology, Medical Council of India for medical education, Architecture Council of India for architecture and related education, and you have the University Grant Commission to regulate the work of the universities.
Government is proposing to solve the problems of interstate universities and 2 deemed universities by the National Educational Tribunals. Sir, are we prepared to give the matters of the deemed universities to the control of National Educational Tribunal?
As far as I understand, every act of the university has a provision for arbitration. And this arbitration mechanism enshrined in the act of the university is a provision by which the unaffiliated institution, if there is a dispute between an affiliated institution and the university, or an employee of the university or employee of an institution affiliated to a university, can very well approach for arbitration. And that's the mechanism where university will be represented, where the employee or the concerned institution will be represented, and you will have an arbitrator appointed by the Chancellor of the university.
In the state level, there will be a state educational tribunal which will be replacing the powers of High Court to solve the matters related to education and issues. So, sir, are we neglecting the High Court stage and directly going to National Educational Tribunal?
In my opinion, this will create another multiplicity of authority. People will run from one place to another, and that way the quality of education and standards of education, in my view, will be further undermined.
According to Professor P.V. Sharma, the mechanism is not really required as most of the institutions are already taking care of most of the complaints. The question I want you to address is, you were making a point on the National Education Tribunal, where only institutions will be able to go. How does that impact?
Well, I think there will be, if there are complaints by the university vis-a-vis the regulatory authorities, or there are issues vis-a-vis the regulatory authority, university versus UGC, university, a college versus AICT.
Yeah.
I think there is a window for the institutions to go and address the issue. Now, as far as the
Points being made
by Sharma, you know, I have difficulty in agreeing with you. You have a High Court, you have a Supreme Court, and yet for the central government employee, you have a tribunal. So there the multiplicity of the institution doesn't hamper, and here it will hamper. I think that's not correct. In fact, what happened, I think it has been rightly pointed out earlier also, that there will be educator there, expert from education, there will be judges, and I think that will be a proper forum to deal with the issue related to education, where there are academic dimension to the issue, but they will be able to understand. It will be a fast track, more relaxed mechanism whereby you can resolve your issues.
Right. The point you were trying to make about autonomy, how could this impact the autonomy?
See, how it can impact the autonomy is that today when we look at the education and we look at the expectations of the students are very different, because the issues which come, and also the parents, the way they expect the things rather than correcting their own children. They look at that the universities or the institutions are responsible for everything. I think it has to be much more than just the education, the character building. With the parents and the teachers or the universities have to play the equal role. Because many times we come across where parents do not understand what their ward or your child is doing, and which is altogether wrong. But then they expect that the son or the daughter has to be favored.
How does it impact autonomy, ma'am?
Autonomy will affect, because for everything they will start going to the tribunal rather than going to the university's own system, which is set up and which is handled by the faculty members of the institution.
What is wrong with that?
No, I think because then all the time the faculty who are involved with that will be moving to the tribunal and answering every single thing and responding to that instead of focusing on the education.
Okay. Now, if the same situation happens in the, let's say, in the public sector, which is the government sector, if the same thing happens, you have tremendous experience in this. Well, do you see a similar problem happening in the public sector?
No, I don't think so. You know, I think going to the tribunal is not a very easy job. You know, you go to the tribunal and you have to prove it, and there is a documentation procedure, there is a cost and there is a time. I think it is only in those cases where the employees are not able to resolve their issues internally that they will go. But I think that will also being a check and deterrent on the institution not to take the issue lightly, because they will know that the employee could go to the tribunal. I think it will have a deterrent, it will have a check, and it will bring a order. I think regulatory framework is always necessary, which brings order, which increase guarantees and assurance to the parties.
What happens when you bring in the judicial aspect into it? For example, there'll be a 50% component of judiciary in each tribunal. Now, once that is ensured, what implication does it have for the education sector?
No, judiciary is brought into in terms of expertise. You know, you ought to have a lawyer who knows the rule. In addition to a vice chancellor, there is a provision of a vice chancellor being the member.
Yeah.
So vice chancellor represents an academic background and perspective, while the person from the judiciary is expert in the rule, and combined together, I think they can look at the issues appropriately.
So it is not going to have an impact?
No. It will have a positive impact. Let me give you an example. University Grant Commission every year declared on their website 13 or 14 institution as their fake university. Now, the people have always come to the UGC, how come you know the university and yet it is an university running as a fake university? The reason is limitation of law. You cannot imagine that the financial punishment, fine for an university to be a fake is only 1,000. And we request the state government to take action, but it's not working. So I think this will bring a lot more order
into the entire
system.
education
I
sector.
think this is a very, and let me tell you one thing which has not been brought into the analysis. Recommendation to have a tribunal is in the 1986 higher education policy. It is reiterated in 1992 action plan. And for your information, University Grant Commission has prepared a draft tribunal bill in as back as 2004, and which was sent to the ministry. So it is good that the ministry has now taken
up this
and
issue.
thanks to them.
Okay. Thank you, sir and ma'am, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.